For more than 47 years, our nonprofit, Resources for Seniors, has supported older adults and caregivers in Wake County. We can help in many different ways, including adult daycare programs, ramps and repairs, in-home supports, and consultation and referrals. Indeed, we're who to call when you're not sure who to call. Resources for Seniors stands ready to support you in your caregiving journey.
I'm Mark Costley, the founding attorney of Clarity Legal Group, the Triangle Area estate planning and elder law firm. You know those people who become overwhelmed dealing with the multiple challenges of being a caregiver? Clarity Legal Group helps people establish legal tools that avoid confusion, give them peace of mind, give them asset protection, and in some cases help them qualify for Medicaid. We help people get it right in the face of some of life's most important challenges. We don't just provide wills, trusts, and powers of attorney. We provide solutions and ongoing support. We provide clarity and peace of mind. It would be a privilege to help you.
Are you like 80% of seniors who would like to age in your current home? Call Wisdom Senior Care. Are you currently taking care of a loved one and finding yourself frustrated, tired, and even lonely? Call Wisdom Senior Care. Always available, dependable, and flexible. Come partner with Wisdom Senior Care, keeping wisdom at home.
Good day, my name is Adam Hopler. I'm with the law firm of Hopler, Wilms, and Hanna. I practice in Durham, North Carolina as a physical location, but many of the surrounding counties as well. Today I'm going to be talking with you about fiduciary roles as a caregiver. I'm going to be focusing primarily on the financial aspects of being a caregiver as we talk here together. But a little bit about myself. I have been practicing law for a little over 9 years now, and primarily in the areas of the word estate planning, estate administration. And what that means is that I'm dealing with stuff. I'm working and planning where your stuff goes. I'm working and dealing with people who have passed away and have stuff that needs to be administered. I'm also working with families who need to put those documents like wills and powers of attorney into play. And so some of what we're going to talk about today is when I assist others in acting as a caregiver for someone else in a legal capacity. And so the big word that we're going to be utilizing is fiduciary. And this is going to cover a whole litany of different roles that a person can play when they're actually caring for someone else. So as our definition here shows, a fiduciary is one that is legally required to act in the best interest of someone else. And that's important because that concept, that idea is something that we're going to deal with quite a bit. I'm going to break this down into larger categories of different ways that people can act for one another into three bundles, if you will. Kind of an informal role in which folk can act on behalf of someone else. What I'll refer to as like an involuntary scenario where someone gets set up to act for someone else. And then what I'll consider maybe the more ideal scenario where you have voluntarily been put into a position where you can care for someone else. And so we're going to walk through those different ideas. So when I refer to fiduciary, we want to always kind of come back and remember that golden rule of acting in the best interest of someone else. And so that's what we're going to be working to do. This is something that comes up a lot in my practice in terms of planning. Where this comes into play is with powers of attorney. And there are, at least in North Carolina, two basic forms of power of attorney. The general durable power of attorney is the one that most people think of when they hear the word power of attorney. And that's the one that we're going to be primarily focused on. But I'd be remiss not to mention that there is a thing of healthcare power of attorney. And that deals with the person, him or herself. I'm not going to really focus on that so much today because we're going to focus on the real financial elements of managing somebody else's affairs. And this is while they are here living with us. So when I sit down and we're talking about planning ahead, if you're the one who's thinking, what do I need to have in place for caring for me in some later situation, a will is going to be pretty basic. A power of attorney and healthcare power of attorney, as well as some other documents that we would refer to as like an advance directive or a living will. But that power of attorney is one that we're going to focus on quite a bit. And so this brings up a really important distinction as well in terms of how somebody can wind up caring for you or how you might wind up caring for someone else. And that gets into a question of capacity. And so I want to take a second here just to discuss that there can be times in life where you fully understand what it is that you are doing, and there may be times when you don't, and that can apply to those around you. In the most basic sense, we see this played out in front of us with children. Children who are under the age of 18, we presume them to be incompetent. And that word carries a heavy connotation to the normal folk who use that word when we say incompetent. It sounds derogatory almost. But for the law, all incompetent means is that you're just not in a position to be able to manage your own affairs. You don't understand what it is to make good decisions. There's something that has broken that down. For children, it's literally that their brains are being fully developed over time. And so while they are developing, we're not going to entrust them with all the ability to make their own decisions. And so that's important to note because when we talk about words like incompetent for adults who are over the age of 18, we're not meaning anything in the way of saying that this person isn't smart or capable. It's just to mean that for whatever reason, they have a medical situation that's come up that they now can no longer make decisions for him or herself. And so this is a real fine line distinction that we always have to address when we start talking about caring for someone else. Because when you act in a fiduciary role, you may be doing that with the cooperation of somebody else. And you're going to need, in fact, have to have that cooperation if they are competent. But if the person has reached a point where they're incompetent, no longer able to make their own decisions, that's going to change our analysis in a rather heavy way. So as is listed up on the screen here, you can see that there are some different examples and ways that folk wind up having a fiduciary power over others or with others. So as I mentioned, power of attorney. Now this is a voluntary type situation. So if I'm sitting in my office and I'm working with someone and they're saying, I want to have a plan for caring for me, they can go ahead and voluntarily name the person or succession of people that might carry that role, being able to use their financial means, again, for the benefit of that person who set up the power of attorney. So another way to think about this is that a power of attorney is not something that you can get over someone else. Sometimes I'll have folk that call up and they'll say things like, I need to get power of attorney over my mother. And I understand what they're trying to say, and it's not anything nefarious. It's just, it's a slight nuance in what's happening. A power of attorney is something that is voluntarily given. And so our correct terminology in that case would be that you would need to ask your mother if you could be set up as her agent, her power of attorney in kind of a general use of that word. And in that case, you would be given the ability to act on her behalf. That's what's happening when we talk about power of attorney. We also have guardianship. Now, guardianship is where we are getting something or something is being taken. This is an involuntary type situation. So if you do not have a power of attorney in place, then what we would need to do is go to the court and ask them for guardianship. And so we would say, court, this person needs their finances to be managed, to be cared for, to use for their best interest, but they can't use that authority because they are, again, our word, incompetent, unable to manage their affairs for whatever reason. It could be as basic as being comatose. It could be more complicated, having dementia or other kind of mental cognitive breakdown that's interfering with rational thought. They're just not thinking things through well anymore. And in that case, we would go to the court and say, we have to demonstrate this person needs our help. So that can be an instance where somebody has a fiduciary role. They are caring for someone else. The court has given them that authority. Another is trustee. Now, a trustee takes us back to the attorney's table when you're sitting there and you're planning, what kinds of things do I need to have in play for others to take care of me should something happen down the road? A trust is not an alternative to a will, but it is a partner document that a person can set up with a will. And so if a person says, I would like to establish a trust, what they're saying is, I want to place my things into the care of someone or something else. And a trust is really more like a business than it is a true person. But it is something that we're going to yield our things over to for that purpose. And so a person who is acting in a trust capacity, a trustee, is managing assets that have been given to this trust entity. And then finally, we have representative payee. Now, a representative payee is a person who is working typically with government entities, Social Security, the VA, and there are benefits that a person is owed. And so it is possible for you to set up with that government entity something that would make it clear that this other person is going to receive your things on your behalf. And that's going to be a very special, nuanced relationship between you and that government agency. So let's start taking these things, and I'm going to kind of put them into these bundles for a minute, and we're going to work through what these situations may look like. So option number one that I want to walk through with you is informal management. So this situation is going to be really the idea that you are voluntarily working with a family member of yours. And I think the common scenario is going to be one of you caring for your parent or caring for a grandparent, somebody who is your elder, more likely than not, or somebody who, again, has some kind of special needs that prohibits them from being able to do all things on their own. But in this case, you do have competency. The person that you're working with, while they may recognize limitations, they know enough about their limitations to know that they need help. And so they're actually coming to you and saying, I want you to assist me in managing my finances. And so there may be some of you right now who are sitting there going, yep, I know exactly what you're talking about. That's the scenario that I'm in at this very moment. And so some of the things that you might do with that individual to try and help them along is to set up that representative payee status that we discussed before. And so that would look like you going with them to the Social Security Administration or to the Veteran Benefits and trying to voluntarily have the individual that you want to care for say to this agency that they're okay with you receiving their funds, right? So that's voluntary. Very clearly, it's a situation where you're like, all right, cool, we're going to work together on this. And you do not have to have power of attorney or a guardianship in place for you to be set up as someone else's representative payee. Now, you will begin receiving their money from Social Security or from the VA, and that agency is going to expect you to keep account of the money that you're receiving on their behalf. And so these are going to be some of the things that we'll talk about here in a little bit, but this creates a situation in which you are trusted to do what is in that person's individual benefit, not yours. So you're going to want to keep good records, one thing that we'll kind of come back to. So that's a representative payee status. It's also possible that you may have an individual that receives other forms of benefits, an annuity or some other kind of pension, and they already have it set up so that it's going right into a bank account, a direct deposit type situation. And they say to you, I want your help. Well, what some people will do is set up joint bank accounts. And if you have a level of trust with someone where you're thinking, I can give them access to my account and trust that they're going to use my money for my benefit, then this could be an ideal situation that, again, does not involve necessarily going to court or otherwise having to get legal documentation in place. There are some cons to that scenario, which I'll come back to, but just for the moment, in terms of setting up an informal arrangement, setting up a joint bank account is something that people do. And what you're actually saying when you do that is that both individuals, if they have their name on the account, are essentially saying by law that they trust one another with the money that goes into that account. If money comes for mother and you're trying to use the money for mother for her benefit, that's what you're essentially certifying, unspoken, but it's there, that these assets are hers. You recognize that because that ownership doesn't change. The access to the account changes, but not the ownership. And that's really hard for some people to grab hold of because that's a major distinction in how this will be looked back on. Like if somebody goes back and they pull that account up and they see that you're using mother's money for your own benefit, that's no different than if you had just stolen the money or just taken it outright without telling her. You're not given permission just by having access to account to use somebody else's money for your own. But having access can give you the ability to pull cash and otherwise make payments. Now, I'm going to hit on using cash, that it is a thing that people do, and it is one way to have an informal kind of management because cash is not traditionally tracked, and we're not going to usually go into a whole lot of accountability on that. And so that can be utilized, but it has a lot of risk. We'll hit on that as well. But having a joint account enables that possibility. Deeding property. If somebody has real property, the real property they have is actually controlled from an ownership standpoint by whatever is filed in the Register of Deeds in the county in which that person resides. And so it's important to take note that if your mother is the sole title owner of a plot of land in Granville County or whatever, that title is established and only mother is going to be able to deed that property, sell it to someone else, or to really use it for other purposes, to give agreement to farm it or to plant on it or to build on it, or whatever somebody might want to do with property or existing buildings that are already on that property. However, it is possible for family members to say, well, we'd like to share ownership. And you can have a deed that is executed, but this again has to be voluntary. This is mother understanding exactly what she's doing. She's essentially making a gift, unless it's paid for, by giving a certain percentage interest to another family member. Now, once two people have ownership and access to land, well, they're able to do what any landowner would do with it. They can build on it, they can plant, they can grow, sell, etc., but they can't sell all of it without having the agreement of both. So it puts a little bit of restriction, but it also grants some access. So these are things that people will commonly do, but what are some of the pitfalls of these various issues? Well, again, going back to the representative payee status, you do actually need to keep account, but there's not somebody over your shoulder telling you that. And it may not be readily apparent how strict your accounting needs to be. If you have put the money that comes from the government into an account that also has your money in it, it can be easy to lose track with when you're using money that's yours and when you're using money that's mom's, and how is that being divided. So you definitely need to take a lot of care to be sure that you have probably had separate accounts created for that purpose, that you have clear receipts and invoices for things that you have done so that you can show that this wasn't done for yourself. Going back to cash, if you pull cash out of some kind of a joint account or representative payee account, nobody knows what you've done with that. So if somebody were to get upset and make an accusation, it's very hard to defend yourself to say that you haven't been acting in your best interest instead of your mother's who you're caring for when you've been taking cash out. How do you prove that the cash that you used was for you or for someone else, or that if you did use it for mom, that there was that cash in particular and not some other source? So this can get very messy really quickly. If you're in a position of trusting someone else, this is, as you can see, pretty hairy as well, because you have little guarantee. If you give them access to your joint bank account, well, they can take all of it because they have access, even though they don't have ownership. So they might not do what's in your best interest, whether they think they are or not. And once they've taken the money, it's hard to, well, there's really no way to stop it, first off, and then it's hard to get it back. Like once the money is out, there's very little recourse that's effective to go back and get that person short of a lawsuit. So you need to be very careful in setting up an informal management style because there's very little control, very little guidance on how a person is going to be able to hold someone accountable for using that. So this is certainly one way that you can do things, but it's not at all what I would recommend as your primary way of doing things. It can be helpful to accomplish simple tasks if you don't have a lot of money. Sometimes folk who are only receiving Social Security may not have much to manage, and so there's not a whole lot of need to go to a court and establish a lot of authority if we don't have real property, etc. So while it's something to consider, and maybe some of these tools might be used in tandem with other things that we'll discuss, the idea of doing a completely informal management style is probably not desirable. Now, as it relates to our next idea here is involuntary management. This is essentially what happens if you, I'll say, get caught, right? Our first scenario, option one, critically hinges on the idea that the person that you are working with has their own competency, right? They are able to voluntarily participate with you. They agree to put you on the joint account. They agree to put you onto the title of the property. They agree to go with you to get representative payee status. But if the person is not able to agree, right? If there's question about that, and you don't have the power of attorney or a trust or some other kind of financial management, then what you're talking about is going to the courts, and that's going to be your option number two. Now, for some people, looking at their family scenario, it can actually be a part of the plan to say, well, I have certain people that I trust, but I'm not so sure that I trust a lot of people with my financial management. I'm just concerned. It may not be about a matter of love. It can just be a matter of I love them and I know them really well, and I don't think that this is something they'd be good at, in which case you want a high level of accountability. That's where guardianship comes into play. So guardianship is where you're going to have a public proceeding that puts on display why it is, if it's you that we're talking about, why you are incompetent, or if you're trying to obtain guardianship over someone else, why that person is incompetent, what medical situations have arisen such that they can no longer manage their own affairs. The court would have to agree that that is actually factually the case, make a declaration that you are incompetent, and then have a discussion about guardianship. Now, the documents that we'll get to, like power of attorney, and you can actually say there for guardianship, well, this is the person that I would want to hold that position if it becomes necessary. I'll explain how that could be in a minute. But if you have not given any kind of direction about who should be your guardian, then the court is going to essentially open the floor. Now, usually there is a petitioner, somebody who started the proceeding, and that person is going to say that they think they should be guardian or that they have in mind who should be the guardian. And so we're going to start there. We have somebody to work with, but that doesn't necessarily limit the floor. Other family members have to be noticed, other interested parties, people who have close relation have to be told, and when they are informed, that gives them the option to say, I would like to be guardian, or I would like to be involved in this particular way or that. So the court will have to now field that as a part of this proceeding. An unfortunate and almost ironic outcome of a proceeding of this kind can be that the people who should be working for your benefit collectively, operating together, suddenly find themselves in an adversarial position. They're now fighting for the position of being able to care for you because they all love you so much that they think they'll do better than anybody else. And so you have a lot of well-meaning, loving folk fighting the other well-meaning, loving folk. So guardianship can be necessary, especially if you don't have documentation. But even if you do have documentation, you want to envision this possibility and give us your priorities. And so you can spell that out. So our third option, the voluntary management option, is what I'm going to advocate to you as our ideal situation, right? You take the time to sit down and say, if I become incapacitated even, not necessarily incompetent, just incapacitated. Like, I can't take care of things as well as I would like. This is the person, or these are the people that I would look to in that scenario. So as I mentioned, we have clearly your durable general power of attorney, your normal power of attorney that deals with finances. You have healthcare decisions under a healthcare power of attorney. Those are going to be basic. You want to have that laid out. Now, to kind of go into just for a second, you can still have a power of attorney put into play and have a nuance in which you still need guardianship, even if you have the best planning. And it's an unfortunate scenario that can arise where a person is incompetent in such a way that while they don't really understand what's happening, they still have the ability to verbalize something else, right? And you may have been in an unfortunate situation to see this, where a person with dementia, Alzheimer's, et cetera, is still verbally expressive. They're saying, this is what I want, this is what I want, this is how we're going to do things, but the decisions that they're making are not based in rational thought. They're not based in actual fact. And a doctor might be aware of that, but if there's no legal decree, we have to still give that person credence, credit, that, well, that's what this person with their American rights and freedoms and, that's what they're saying. So we have to listen to them because legally that's where we are. And so you may be in a position where you have to go to a court and say, I want you to declare the person incompetent so that nobody else will listen to them. That's what happens when you say they don't have that authority. So one distinction that you might make between a power of attorney and a guardianship is that a power of attorney is like taking the authority that you have and duplicating it. We now have a Xerox copy. So I'm going to hold the authority and you're going to hold the authority, and we're going to work together to kind of fill in the gaps. A guardianship, though, is where we take the authority. We can't duplicate it because we don't have voluntary participation. And instead, we just hand it over to somebody else, right? So now this person, the guardian, has the authority that you once had. And that can be necessary, again, if you're actually acting against your own interest. So a power of attorney, though, it's still very helpful. Why? Because of what we said before, which is you declare the person incompetent, right? You take the authority away. You got to give it to somebody else. How do we decide who to give it to? We look at the power of attorney, because the power of attorney is going to say, this is the person that I want to act as my agent. So even with planning, there may be things that hiccup along the way, but the planning is still going to help us deal with those hiccups. So I want to spend the remainder of my time talking about what you as a person who is responsible for someone else really should be doing. So we've spent a lot of this time kind of setting up the premise that there can be different ways in which you have a fiduciary obligation, because whether you're acting informally as a representative payee or joint account holder or somebody else who is on a deed, or you've just been given a general instruction, or you have that involuntary guardianship or power of attorney put into play, all of those scenarios, you are being asked not to act on your behalf, but to act on the behalf of someone else, right? So it's important to know when a personal obligation comes into play. With the vast majority of these options, even with having a power of attorney, there's not a personal obligation to act, right? And there's also not a taking on of obligation of the other person. So to say it this way, if mother has a credit card that she's racked up, $20,000, and suddenly you start acting on her benefit, and the creditors are calling up and they're saying, well, mom owes $20,000 and you're responsible for her. Well, they would really like you to pay the $20,000 credit card bill, but that's mom's responsibility, not yours. Now, you may be in a position where you're managing mother's stuff to try and deal with that debt, making payments, challenging it, or figuring out some way to pay the whole thing off. You have to do an analysis of the situation, but however you're dealing with it, you're dealing it with your mother's assets, with your mother's things, right? So this does not suddenly become your personal obligation to pay someone else's debt by taking on this fiduciary responsibility. Even in a guardianship would say, okay, you're the guardian, You do have to deal with it, but you have to deal with it with your mother's things, right? We're still not going to say that it's your personal responsibility to pay for what your mother previously owed. This is really critical because you can almost think about this from a standpoint of your own sanity. As caregivers, so much pressure gets put on you to think about how it is you're going to manage someone else. And so what you have to do is recognize that there is a distinct wall of separation financially, as in other places as well, but at least financially in terms of what you have to do or can do for this person that you're caring for. And so if you're not sure where that wall is, then it becomes, I think, important for you personally and doing this well to find out about that and to ask, where is this wall? Like, when is this my responsibility and when is it not? Because if you don't have that understanding, what you are liable to begin doing is overstepping your bounds and just making things more difficult than they need to be, and maybe even creating liability when there wasn't previous liability, right? Mom has to have a place to live. Okay, all right, so we need to get mom somewhere where she needs to live. But do you have to sign on as a person responsible for the debt of that particular facility or place that she's living? Well, probably not. You may use your authority as a power of attorney, etc., to authorize her to be there, but it's a big deal, and it's a question that needs to be grappled with, like who's actually responsible to foot the bill when it comes due. So take the time and think through those kinds of financial distinctions when you begin taking on responsibility. And again, all but guardianship, you don't have, again, even an obligation to do these things at all. You just need to make sure that whatever you do it with that other person in mind. So if you're the one who's acting as a fiduciary for someone else, you just have to be acting in their best interest. So try really hard not to go across that dividing line. So what can be really helpful in a situation like this is to begin to set up parameters, blinders, that make it clear where you should be looking and where you should be going and where you should stay away from. So for instance, we talked about joint accounts earlier. And while joint accounts can be helpful, joint accounts can be confusing as well, right? Especially if you are using funds from multiple sources. There are some counties in North Carolina that if you become guardian, they will want you to account for everything except for Social Security. Or it may be that they say, we don't even need to have a guardianship over your stuff, the estate, if all you have is Social Security, right? So in that instance, making it really clear, okay, I'm going to set up a special account for Social Security only. And so I can show very clearly that the only expenses that come out of this account are expenses that belong to, again, mother or whoever it is that you're caring for, right? So you don't ever use that for anything else. Now you don't have to worry so much about making a mistake by, paying for something that is yours out of the same account because you don't have your money in the account, right? So you don't commingle funds. That's a big deal. You may also need to have multiple accounts depending on what kind of planning was done. So it's possible that somebody sets up a trust and they name you as the trustee over land or property or a certain account, an investment account. But they missed a few things, or they're receiving Social Security, right? If you're going to have to be accountable to the federal government for what you're doing with the Social Security, it would be desirable that the only thing that they see is what they care about, which is the Social Security. So even though you may be managing mother's money in a trust and in Social Security, maybe even a guardianship account, you probably still want to take the time to set up separate accounts for each one of those things, right? So that whenever somebody says, what's been happening with the trust, all you have to show them is the trust. You don't have to confuse them with what you've been doing with the Social Security or what you've been doing with the guardianship, right? So separation of account can be very helpful, and it can also keep you from inadvertently crossing lines that you may not you should be aware of, but maybe you missed, in terms of what you're supposed to do with trust money versus the great leeway that you have with Social Security. A trust may say you can only use it for these things, right? So you have to know what those rules are. So take time to know those rules, but you want to keep the money that's over there separate, right? A big no-no in terms of blinders is cash. The minute that you begin managing someone else, you want a paper trail, right? You need to be able to, at least at a bare minimum, show that you're doing all the things that you are supposed to do and nothing else. Nothing raises eyebrows faster when doing an accounting and trying to make sense out of what's been happening for a couple years while you've been managing somebody's funds than to see over-the-counter withdrawals or even over-the-counter deposits of cash that are unexplained. Where was this money coming from? Where did this money go to, right? It's important to note that as a general rule, when you are acting as a fiduciary, right? And a fiduciary is a broad term. It's not just limited to power of attorney. It's not just limited to representative payee. It covers all these different things that we've discussed today. But when you are managing something, being trusted by another human being to keep their funds safe and for their benefit, the law is going to impose upon you an assumption, right, that if there's something wrong that happened, that not only was it your fault, but that it may have been fraudulent, actual wrongdoing. So it's very careful. It's very important to be super careful, because while you may say there's not a lot of money, or we're all in agreement, it's very clear that I have the authority. That may all very well be true. But we all know within our families that they are complicated. And we all know that family members sometimes don't get along. And we know that sometimes family members make messes that they shouldn't, but still they do. If you're managing your mother's stuff and her sister begins to wonder what you're doing, there could be legal processes by which she could, if she wanted to, push and push and push to finally force you to account. And if that time comes and there's a lot of cash transactions, we're going to assume that the cash transactions were in breach of the violation of the fiduciary responsibility that you had. And now the burden will shift to you to say, no, that wasn't the case. So as I've talked today, I've said things like being able to defend yourself, to justify yourself, to explain yourself, because that's may actually be what you wind up having to do one day. Now, it's not to scare, it's just to say that that has to be in the back of your mind when you begin managing money for someone else, that you will be held accountable one day. So don't take that lightly, right? Do basic things. If you were to be accountable to a court, for instance, with a guardianship, what would they require you to do? Well, at a bare minimum, they would say, give us an inventory, which is a day one accounting. What did you start with? What assets did you have? What accounts, cars, etc., right? And then from there, what they're going to want you to inform them of is what you have done for the next year. So for a court, they're going to let you go an entire year, taking money, spending money, going back and forth. And then after a year of activity, they're going to demand a down to the penny accounting, right? For every little bit that came in and every little bit that came out, show it, right? If there was a receipt, show us the receipt, right? If there was a payout, show us where it was paid out and the check image or the credit card statement, whatever it is that shows where that money went to so that you can get the connection. So if the court would require you to do that just once a year, I would say that at a bare minimum, that's probably the standard you should hold yourself to, right? Take the time. Pull the last 12 months of statements for the account that you've been managing and just look it over and ask yourself, is all of this self-evident, right? Would somebody who doesn't know anything about what's happening right now look at this statement and say, I can find no fault? Now, if there are certain things on there like cash deposits, circle them. And then once you've gone through the whole 12 months, go back and say, now how can I show that that actually was what it was? I.e., I took cash out to put it into a fund at the at the home that mom is living in so that she has access to go and get drinks and snacks throughout the day, right? They just may have said, well, we need a cash deposit. And so if that's what the case is, you probably want to get something from the facility that's saying, yes, on this particular day, we received exactly that amount in cash from you. Okay, there we go. We have a trail, right? So you can think in your own scenarios as you look through where these issues might crop up. But again, going back, what's important is just keeping that bright line, gold standard in mind all the time, which is a fiduciary is acting on behalf and for the benefit of someone else, not you, for someone else. And so you have to be way above. Whatever you think the reasonable standard is, try and go above it so that it is super clear that you're never doing anything to benefit yourself. Now, that being said, there can be circumstances where you feel like you need to, and those can be quite the quagmire. And so you're going to want to have a lot of communication. You're going to want to really think carefully, if I need to do something that's going to benefit me incidentally, right? The conveyance of property to you and all of your siblings for whatever reason. Maybe it's some kind of Medicaid planning or whatever it might be. But if you're working with someone, you want to be really careful to be able to establish that this, while it may incidentally help you, is still for that primary benefit of someone else. So with that being said, I think it's important to just take a few minutes to think about what we've discussed so far. And so, again, you have the ability to help manage others. And that is primarily, it's not an obligation, it's not a requirement, but it is something that you can do. And so you want to recognize that the minute that you take on that responsibility, that these obligations, this burden of proof, if you will, falls upon you. So you want to take that seriously. You want to think, if you have people in your family that you might be managing in the future, right? What kind of conversations can you initiate with them now so that you alleviate stress in the future? For instance, and maybe this is the fault of attorneys over time. When somebody sits down with an attorney, we almost have to explain the rules of confidentiality between individuals. And so we'll say things like, everything that's spoken today in this room is confidential and I'm not going to be sharing it with anybody else, right? And that sometimes creates this implicit meaning that it's also confidential to you, like that you should keep it private. And that's true. Because it's always your right to do that. You don't have to tell anybody anything. But when you're doing things like planning with a will or a power of attorney or a trust, there can be very good reasons to keep those things private. But there can also be very good reasons to share at least certain parts of what you've done, right? If you have multiple children and you are selecting someone to be your primary power of attorney, or to manage your estate when you pass away, or to handle a trust, should either of those things happen, it can be extremely helpful to make sure that the other children of yours at least have that expectation. They don't necessarily have to know all the details. That could be helpful too. But generally speaking, people, when they hear what you say, they're going to take that with a higher level of credibility than just seeing it written on a sheet of paper. I can't count the times that I've looked at a legal document that was plain as day that this is what the person wanted to happen. But yet all the family members look at it and they'll just say, no, that can't be right because she just never said that, or he never said that, or maybe even said the opposite, right? And that can be concerning. So you definitely want to be careful with your words. But keep that in mind. The power that you have now to set your care in place tomorrow. Don't take that lightly. Work with your family members as to the greatest extent possible to discuss the kinds of plans that you want to have while you can do that. Now, unfortunately, that's not always the case. Sometimes the unanticipated happens. As much as we may well-meaningly meant to have planned in the future, we just did not. And so if that happens, again, I would argue communication just becomes even more important between those who are left behind, so to speak, even if the person hasn't actually left, they're just incapacitated. You want to cooperate with folk as much as possible. Having a level of openness within the family can be so critical to diffusing argument, right? It's, certainly would be jarring for somebody outside the family to come and question your fiduciary responsibility to your mother, right? But it can be really painful when it's a family member because they just don't know, right? So if there are ways for you to diffuse and alleviate, do that. Have the conversation. And then finally, we talked in some terms about making lines and creating blinders. If you are in a guardianship position, and this applies so much with financial management, but it also applies in other areas as well as being a guardian, you really want to think about yourself as being a quarterback. And so what I mean by that is that when a quarterback goes trotting out onto the field, the quarterback is never alone, right? The quarterback always has his teammates in front of him, his teammate behind him, his teammates to the side of him, right? He is surrounded with those who are aiding and supporting him, right? The quarterback doesn't do all of those jobs. The quarterback maybe could. He probably wouldn't do a great job blocking because he's a little guy, but he could try. The quarterback could just run with the ball, but he might not be as good as the running back who's supposed to run. He maybe could catch the ball once in a while, but that doesn't necessarily mean that he's going to be the best at catching, right? His job is to orchestrate. It's to make sure that everybody else knows what the game plan is, that everybody else is where they should be, and if they're not, to move them to where they should be, right? To have everybody in position to execute properly. You have a team as well, right? And so for financial things, you have attorneys, right, that will work with you to help you to understand all the nuances between power of attorney, guardianship, trustee, just being a representative payee or informally managing a joint bank account. All of these things have laws and rules and regulation that can have a dramatic effect on you. Accountants, certainly when you're managing these funds, you need to be able to keep track of them, to understand where they're going, right? Pay taxes appropriately. So you may need to talk with somebody about basic accounting and working through, like, keeping a spreadsheet of what it is that you're doing, right? Organization. If you're in a position where the person that you are caring for was fortunate to have a nest egg to invest, you may want to have a financial advisor, a wealth counselor, right? Somebody who sits down and says to you, well, we can use this money to generate more money, right? We can use it to help benefit this person for a much longer period of time if we will do X, Y, and Z, right? An accountant is not going to draft documents. A financial advisor is probably not going to want to get his hands down into the nitty-gritty of day-to-day accounting, right? But all of these people working together will be able to help you. And remember when we talked about the burden that you have, they're going to diffuse that burden. Because every time you can say, oh, that wasn't me, that was the recommendation of this professional, it's another protection to you. Don't downplay that. It can be so tempting to say, I don't want to pay that expense. I don't want to utilize that service because it just seems like a lot of trouble. But think twice about that, because if they help you to accomplish more than you could on your own, then it has been worth it, right? Don't be a quarterback standing out in the middle of the field just asking to be sacked, right? Go out there with your team. Go out there with your full support. Use what you have. Think carefully about your responsibility. I hope that this has been beneficial to you. And certainly, I am available. Our firm, again, we have several locations, and if there's ever anything that we can do to be of assistance, please don't hesitate to reach out. Let us know how you heard about us so that we can have the appropriate level of consultation. if we can be a resource, that's what we want to be. I hope that as you continue to listen to other presenters throughout your time and going through online, that you find many beneficial things, and that we're happy to be a part of all of what this is. And so I thank you for taking time to listen to me today, ramble on and on. Maybe you had to stop numerous times and go back, I don't know, but I assume that you'll be able to follow back up and kind of look over this if you have additional questions. And so whether that's by call or in some form of writing or online submission, please don't hesitate to take advantage of that. So with that, I will sign off and thank you for your time. Have a good one.